And Chris, if you'd like me to share any documents as we go, just let me know, and I'm happy to do so.
All right, thanks. Well, thanks everyone for being here and taking some more time out of your summer to do this. Much appreciated. And special thanks to Kaiti for getting all that data that I haven't had a chance to look at yet, but will do. I think that's going to help us think about particularly who else we need to get into this group in the immediate future. And of course, if anyone has ideas on that, you can let Sandy or me or Justice Duncan know. So last time we left off with signatures on the notices of appeal, and I'm not sure that we were able to go any further on that. Did anyone remember if there was more that we needed to discuss? I think that the question was, or one of the questions was, does the city attorney need to sign? And I think that there wasn't exactly, we weren't quite sure, as I recall. Did we want to get back into that, or we need to get more input from the bigger group?
Well, I will say we've been looking at the notice of appeal requirements for justice courts in the draft bill. If you look later in the draft bill, I think it's around section 42, 43, you will see that if the city is appealing the justice court or the municipal court's decision, and the city attorney would be the one to sign the notice of appeal. Likewise, if the defendant is appealing from a municipal court, the defendant must serve the city attorney, even if the city attorney didn't appear in the courtroom.
Yes, so we're the next topic is the service, and that's what we're going to get into today. So I see what you're saying about the signature of the city attorney is addressed in section 42 sub 6 for municipal courts.
What I still have as kind of an open question from last time is we were concentrating on section 19, which is only about justice courts. And there was still a remaining question as to who specifically is the entity representing, the government. Is it always going to be a police officer? Is the district attorney's office tracking these cases? Is there someone that we can always name as the person who would sign these notices for justice courts only? Because municipal courts, again, is dealt with in section 42.
Is this a question that we should just add to our list for the larger group, identifying it as an issue, or is there more to talk about here?
Well, I'm pretty sure the current practice, it's very rare in my experience for either the county or the city to appeal from a justice or municipal court decision. But when they do, the expectation, when they do, typically it's a case that involves some principle of law, and invariably the city attorney or the district attorney would be the one handling it, because we don't want the police, we don't want the citing officer who is not authorized to practice law to be filing a notice of appeal on behalf of either the city, the county, or the state.
So in section 19 sub 3, Jim pointed this out last time. When the appeal is taken in the name of the county, the city attorney, and that's a typo, it should say the county attorney shall sign the notice of appeal. But based on our conversation last week, it sounds like the county attorney's office is almost never involved in these types of justice court appeals. So do we just want to remove section 19 subsection 3 Is there
Well-
ever some other entity that's going to be taking these types of appeals on?
No, as I said, they are rare, but if you do have a case that involves some issue of law that the county wants to have reviewed, or if the citation is for a state offense, if the state wants to file, if the state wants review by an appellate court, then again, either the DA or and assistant AG would be filing the notice of appeal, not the citing officer.
Okay, so it sounds like in section 19, subsection 3, if we just make the change to the county attorney, then that can stay as is.
I think so.
I have a comment. Can you hear me?
We can, John. You're welcome
Okay.
to, yep.
This is just from my experience. I don't have any statutes, but to point to, but I've appeared in many justice and municipal courts. And the county attorney traditionally, in all the counties I've ever practiced in, handles the civil proceedings for the county. On the criminal side, the district attorney or a city attorney handles all prosecutions in any court. The county attorney just doesn't appear in criminal proceedings, to my experience. So I really question whether there are any civil proceedings that are initiated in a justice court or a municipal court where a county attorney is ever involved. I don't know if anybody else has any collective wisdom on this, but that's just what, or maybe statutory is probably be a better place to look, but I just don't see that ever.
If the case involves a violation of a county ordinance, is it still the DA who handles the case, not county council?
Now you're asking a different question. You're using two different terms, county council and county attorney. Now,
County attorney.
well, let's just use it and let's just talk about Clackamas County and Multnomah County and Washington County. There's county council and the district attorney. That's it.
Okay, so if
There's no entity called the county attorney. There's county
Okay.
council.
if the defendant is charged with violating a county ordinance only, that's the
Yes.
only charge.
And it's a civil ordinance like a nuisance.
Yes.
Excellent. Okay. That is handled by county council in my experience. I can't point to any statutes, but a lot of this is stuff that's handled, enacted as a result of county ordinances that created county council. So you're not going to find them in ORS. You'll find them in the respective county ordinances.
What if the defendant has been cited for what would be a traffic or other offense, except it has been adopted by the city as a violation? Or maybe I should back up. Do counties have the authority to adopt, as cities do, offenses such as speeding, drunk driving, etc., as county ordinances?
Let me back up. Where would, if they did, and I don't think they do, If they did, what court would they bring them? What would they prosecute those violations in?
I assume in justice court. Same way the cities prosecute alleged violations of municipal ordinances.
I wish Dan
And-
Cross was here because he could answer this from his practical standpoint, but there's no county attorney that there. Dan Cross will tell you that they don't have any attorneys prosecuting violation cases in his court. And I think that's the same in all justice courts throughout the state of Oregon. For violations, the county doesn't want to spend money on lawyers to prosecute penny ante traffic violation cases. Cops can do it, and they do a fine job of it.
And if you remember, a number of years back, the city of Portland adopted as, I believe, a violation of the municipal ordinance, something that impinged arguably on free speech rights. And there were something like 200 or 300 people. It was park. I don't remember. It was park exclusion rules. And the Court of Appeals received something like 200 or 300 appeals. And those were handled by, as I understand it, the city attorney, because it raised a constitutional issue of whether those violations, whether those ordinances were valid. So it is true, it is rare that city council or the DA is going to appear in a justice or municipal court not of record. But when a case raises that kind of major constitutional issue, or for instance, if the defendant filed a motion to suppress evidence in a violation or misdemeanor case, certainly the city attorney or DA, I think, would get involved in that case, which may be only one every five years, but when those kind of legal issues are raised, my understanding is that they then do get involved in the case.
Jim, thanks for reminding me of those cases you're talking about. Those arose, if my memory serves, when Portland had a municipal court. If this shows our ancient age compared to the other members that are participating. But do you remember that the old municipal court used to be held at they called 2 and Oak, which was the old police department building at 2nd and Oak?
I was never there, so no,
Okay. Well, I've got years on you. The municipal court in Portland was abolished, and it was joined into the district court, which was an inferior court when we had the district courts and the circuit courts throughout the state of Oregon. Later on, they got collapsed into all circuit courts. But the cases that you're talking about, if my memory serves, arose from the Portland Municipal Court. But that is no more.
right, and that
So it wouldn't occur
actually,
anymore.
where do those cases go?
Well, they stay in the municipal court where they're brought, if assuming that a municipality has a municipal court.
I mean, in Multnomah County, in the city of Portland.
Oh, all traffic violation cases, with the exception of municipal courts and justice courts, and there are some municipal courts in Multnomah County. Okay, Troutdale is an example. Okay,
But
So-
not in the city of Portland proper.
Multnomah County. Pardon me, Multnomah County. There are municipal courts and there are justice courts.
I believe if a municipality hits a certain number of folks by population, by law, it has to be, everything goes to the circuit court. I think that number is, I can't remember exactly, but I think it's 300,000. So every other county besides Multnomah County, you're gonna have municipalities and their codes. And I also think by law, those municipalities have to adopt the traffic ORS. So you have the dual jurisdiction with municipal courts, circuit courts, and the circuit courts and the municipal courts will both have all their violations cited under the ORS.
Do those cases end up getting prosecuted the same as misdemeanors in circuit court? Because one of the things that's interesting about the data that has been furnished to us is it shows that counties like Clackamas County and Washington County have well over 100 cases, whereas Multnomah County only has 8. And there has surely got to be as many or more similar cases in the city of Portland. But where those cases end up is obscure to me. On the other hand, maybe we don't need to worry about it because the laws that govern justice and municipal court simply do not govern city violation cases committed within the city of Portland.
I think all of those Multnomah County cases are probably the Troutdale Municipal Court appeals, because without any kind of Portland Municipal Court, all of those Portland city ordinances are prosecuted in circuit courts. They're not going to appear in the data. That's my understanding of it anyway.
So they would show up in the Court of Appeals as appeals from Multnomah County Circuit Court.
I think so.
Okay. And do you know what procedures Multnomah County Circuit Court follows in the prosecution of those city ordinance cases?
I have a little knowledge about that. That has to do with firearms law. The city of Portland is somewhat unique. Even if you have, well, I don't want to overstate this. In the city of Portland, there's an ordinance that prohibits you if you're having what's called open carry. If you have, where it's legal to pack a gun on your seat of your car, you don't have a concealed weapons permit. If you are driving throughout Multnomah County, with the exception of Portland, you can have it loaded, sitting on your seat in plain view. Once you go into the city of Portland, it's a crime to have it loaded. Those kinds of cases, to my memory, are prosecuted by the district attorney in district court, even though it's a violation of the city ordinance.
You mean in circuit court?
Circuit court. So, I'm
Circuit
sorry,
court.
in circuit
Okay.
court, yep. And they're rare.
You used the word crime. You said it was a crime.
Yep.
Do you know what the punishment for it is? I mean, is it,
It's
can you be,
it's a potential
in prison?
jail sentence.
pardon?
It's a potential jail sentence.
Okay.
I don't remember, I know it's a misdemeanor. It's not a felony.
Yeah, I want to say it's like a B misdemeanor or something. It's possession of a loaded firearm in public is the actual offense. And a lot of municipalities have those ordinances.
Okay.
Okay. Well, okay, then it sounds like we don't need to worry about the city of Portland because those cases are going to be prosecuted as if they were state crimes. And so those cases will be governed by statutes other than the statutes we're looking at here.
You know, I'm gonna have to say, I gotta scratch my head and say, I don't know. I wish we had a Multnomah County prosecutor. on this panel. I could call somebody quickly and find out, but darn it.
I guess, I mean, does it hurt to put the, you know, if the appeal is taken in the name of the city, then the city prosecutor signs? Is that the question here, or did we go somewhere else?
Yeah. Yeah, that's what I'm thinking. After going round and round, I think at the end of the day, maybe it doesn't matter, because if it's a city, if the defendant has been convicted of, or has been charged with the city ordinance, and the city wants to appeal from it, then the city, oh, well, I guess, as John Henry pointed out, the proper term is county council would file the notice of appeal, would sign the notice of.
So in section 42 uses the term city attorney, and the city attorney is signing the notice of appeal. And that makes sense because it's municipal court. But section 19, if we change that to county council, when the appeal is taken in the name of the county, I think that, according to John, it sounds like that might not never ever happen. But if that never happens, then there's no harm in putting that down.
The county would be different than city, wouldn't it?
Well, now
Well-
we're talking about section 19, which is justice of the peace, or it's justice courts only. And
No.
you would never have a city attorney prosecuting in a
I see what you're saying.
justice court, right? That, at least I don't think so.
No, but I'm gonna say, when you're looking at section 3 of subsection 3 of section 19, you're never gonna have a city attorney prosecuting on behalf of the county, right?
Right, but we're saying that's an error. That's a drafting error.
Okay, so
And that
if it-
should, and what we're going to change that to is county council. And it sounds like that might never happen, but if the county ever were to want to appeal in the name of the county, it probably would be the county council.
Would have to be.
Okay.
I don't know who else it could be. Okay, well,
Yeah.
Okay, so we don't need to address city attorneys at all in the justice courts section. Is that correct? And so we're leaving in county council in section 19, or putting in county council in section 19, leaving city attorney in section 42. And is that all we needed to address as far as signatures?
I think so.
Okay, great. Let's move on then to our next topic, which is service. And the summary document that you were sent, that Justice Duncan put together, pulls together most of the provisions. Section 10, section 20, or section 10, 11, and 20. But those are just the justice courts sections. So then there's also the municipal court sections, which would be 43 and 44. And then I had a question also. I don't think small claims is addressed in here at all. Is that accurate?
So small claims would be civil cases. Actually, I believe that was a question I had. How are small claims court cases handled in courts of record? Well, I guess the answer, we don't know, because there is no justice court of record. There's no justice court that has chosen to become a court of record. So I frankly don't know what could or should happen in such a case.
So in the current statutes, the small claims, there's a specific form of appeal in ORS 55.120. And I don't think that's addressed in the draft statutes here that we have. I think that the ORS 55.110 is incorporated, but that's the only reference to small claims that I see in our draft, unless I'm missing something. So I think that the procedure parts are currently not in our draft.
Well, some current statutes are not mentioned in the bill because it didn't seem appropriate. I didn't have any thoughts for how we needed to change them. So it may be that I looked at that section and so that's fine. There's nothing to change about those.
All right, well, maybe we can take a look at that in the context of the Justice Court provisions here. And I note that in our draft, the Justice Court provisions are divided up a little bit differently than the municipal court provisions, although they all ultimately address the same issues. But so section 10 and section 20 are separated as far as defining who the adverse party is. It's like partially in section 10(2)(a) and partially in section 20. Whereas in section 43 and 44 for the municipal courts, it's kind of all put together in the same place. So I thought that might be something to look at, is if we need those separate sections. And then also section 20 doesn't address civil appeals. And I don't think that there is a similar section for the civil appeals that I'm seeing.
Okay, I see. Okay, I'm now recalling what I'm proposing here. The draft bill would repeal that ORS 55.110, was it? You said that address service?
Let's see. So 55.110, I think, is incorporated into the draft bill more or less, but it's 120 and 130 that
Okay.
are not, or specifically 120, I think would be about the appeal.
Okay, so the draft bill does not repeal 55.120. Nor does it amend it. Well, what the original thought was that section 10 would address filing and service of notice of appeal in both civil and criminal cases. And then section 20 has additional service requirements in the violation and criminal cases. You don't need that in municipal courts because municipal courts do not have civil jurisdiction. So you only need one section addressing service in municipal courts.
I guess maybe that's the answer to my question about whether there needs to be a section like section 20 to define the adverse parties in municipal courts, but perhaps that's not the case.
Yeah, because I think in municipal court, you always only have the city and the defendant. Whereas in a justice court civil case, you can have a plaintiff and defendant. Actually, in a landlord tenant case, you could have perhaps multiple defendants. So you need somewhat different wording for justice courts for civil cases that you don't need for municipal courts.
All right. That's education for me from the experts here. That's what I wanted to check in on. So it doesn't sound like there's any reason to have a section like section 20 for the civil appeals. And probably doesn't make sense to combine that section 20 with section 10 like it's done in the municipal court sections.
Right.
So then I guess the question about the small claims, it does seem like the procedure. Well, the procedure in ORS 55.120 is somewhat truncated in respect to some of the other sections that we're doing, but perhaps it's sufficient and that's not something we need to address.
Well, actually, you now raise the issue that if section 10 is intended to address filing and service of notice of appeal in civil cases in justice court, at least as to small claims cases, there may be some overlap or inconsistencies there that I failed to make note of when I went through this the first time. So I'm going to have to compare 55.120 to section 10 to see if those two mesh.
All right, great. Since we didn't have that done in advance, that probably makes sense to do outside and then readdress.
Yes.
Thank you. Okay, so those were my kind of big picture questions. So do you want to just go through? Well, I guess first of all, the courts of record, is there any concern with just applying the normal procedures for appeals to the Court of Appeals for the courts of record as far as service?
Yes, there is.
Okay.
And the reason is that chapter ORS chapter 19240 requires service on the transcript coordinator. Justice and municipal courts of record have no such position. So in essence, the justice or municipal court clerk or administrator serves in that role, and there simply is no such person to serve. Circuit courts by law are required to have a transcript coordinator. Justice and the municipal courts are not. So, the way it's been handled is that the appellate courts have simply been treating service on the trial court clerk as service on the trial court as service on the transcript coordinator. And so I think probably the wording of the statute should be modified to conform to what the current practice is.
Any other comments on that? So, yeah, so it would just be a slight modification to that, it sounds like.
Yeah, it'd be somewhere in section 20. Oh, wait a minute. Oh, yeah. Now I'm not recalling how we dealt with that. Jessica, do you recall whether the draft bill treats appeals from courts of record and from non-courts of record differently?
I think it's section 7 talks about appeals from courts of records for justice court.
Right, there's that kind of initial statute that says courts of record go this way, non-courts of record.
Okay,
So it sounds like 7(1)(a), just directing people to chapter 138 wouldn't quite work in some circumstances.
well, for both. Yeah, because as the memo points out, 138 says services accomplished as provided in chapter 19. And it's chapter 19 that says that you have to serve the transcript coordinator. So we need to have exceptions, I think, in both 1A and 1B, that you don't need to serve the transcript coordinator.
Sounds right to me. Any other comments on that? All right. I think the next question on Justice Duncan's sheet was whether there are any circumstances other than the one set out in ORS 138.081 involving constitutionality in which the city attorney should be served.
Well, yeah, this gets us into the issue of whether under current law, appeals from municipal court cases in which only a violation of a city ordinance or charter is alleged, that the defendant cannot appeal unless the case raises a constitutional issue. I wrote a memorandum that calls into question whether that's the current state of the law, and that's one of the major issues that I think that this work group is going to have to address. But I don't know that we need to resolve it here. I think it's adequate to say basically just if under law a defendant may appeal from the decision of the municipal court, then service is on the city attorney. Yeah, is on the city attorney.
I agree. I think that's definitely a large question for the bigger group. And I think city attorney is correct. Even though we have a city prosecutor's office, we have a city attorney as well. So it makes it to us. And I think other municipalities use the term city attorney. So I think that's fine. Which section of the draft bill is this?
Let's see. Should be somewhere around section 42 or 43.
Yeah, section 43.
Thank you.
Now, I thought we were talking about appeals from courts of record for that question. And that would be section 38. Is that also a question for the courts not of record then?
Well, I think it doesn't matter for service purposes, whether it's a court of record or not a court of record, notices of appeal should be filed by and served on the city attorney. Because that's who's going to be handling the appellate case.
So do we need an addition to section 38 then for the courts of record?
Well, no,
Yeah.
section 38 sub 1 addresses appeals from municipal court of record, and then 1B addresses appeals from municipal court not of record.
So the not of record would point to section 43, which says service on the city attorney. But the problem is people who are pointed to chapter 138. Chapter 138, of course, doesn't mention the city attorney. So do we want to have some sort of exception that requires service on the city attorney? That's what I'm understanding the issue to be.
Or is that a section 1 or ORS 138 change?
Actually, I think it's in 138. Do I have that in front of me?
It says 138.018, 138.081. It mentions the district attorney for the county, or if the appeal is under ORS 221-360 on the plaintiff's attorney.
Yeah.
Is that going to
Yeah,
be the
we
city
may-
attorney?
Yeah, I think we probably should change that. That's kind of awkward to refer to the city attorney as the plaintiff's attorney.
Okay, so part of this bill would be amending 138.081 to reference the city attorney for these types of appeals from municipal courts of record.
I think so, yeah.
Okay, great. Next question that I have is note that. Oh, maybe this is the same thing. 138.081 refers to the state, and that in some cases in justice and municipal courts, a city may be the plaintiff. So I'm not sure if I understand that since I'm not an expert in this.
Yeah, municipal courts have jurisdiction of traffic offenses and misdemeanors and violations under state law if committed within the city boundaries. My understanding is that that's extremely rare because cities, in order to capture that revenue, basically adopt all those offenses as municipal ordinances. And so when the person is stopped by a city officer within a city, the person is cited for violating the city ordinance. But in theory, you could have somebody cited into municipal court for violation of a state violation or misdemeanor. So you have to probably account for that, even though it's not very likely.
So what is the wording change in 081 that's being suggested here?
So I think we're going to amend 138.081 to, well, and once again, it doesn't matter whether the appeal is from a municipal ordinance or from a state offense charged in municipal court. The city attorney, if an appeal is going to be taken, would be the one signing the notice of appeal. Likewise, as far as service goes, if the defendant appeals, service would be on the city attorney.
Krista, you were muted, so I don't know.
Oh, well, that was really helpful. Thanks. Is the issue in 138.081, one small a, large B, when the state appeals, does that need to include when the city appeals?
Well, I think 138.081 only addresses service.
Right. Would there be a situation when the city is the appellant, though? And then,
Well, if the city is the appellant, then it's serving the defendant, which is covered under other law, not 138.082.
okay, so
Only
this,
one, excuse me.
so you're saying there would never be a situation where the city is the appellant under 138.081?
Well, what I'm saying is that 138.081 only addresses service requirements.
Uh-huh.
When the city appeals, and actually it only, and 138.081 address services on the government entity. It doesn't address service on the defendant.
It
Which
does. It says when the state appeals, the service is on the attorney of record for the defendant. So I think the
I see.
question is,
Okay.
would it not necessarily be the state appealing, but the city appealing?
Yeah, the rule should be same. If the statute is silent on that, then that needs to be addressed.
Okay, so looking at section 34 in that line 11, we need to account for when the city is going to appeal. Do we also need to account for when the county appeals? Is that ever going to happen?
In theory, yeah. I mean, it could, as I said, it's very rare that the city or the county is the appellant, but it can happen. And so we need to address those situations, however rare they might be.
Okay, any other comments on that before we move on?
I just have a quick revisit to the trial court transcript coordinator. Because chapter 138, specifically 138.081 1B, which is again section 34, says on the trial court transcript coordinator, if a transcript is required in connection with the appeal, that resolves any issue with there not being a transcript coordinator in municipal courts and justice courts. So it's really chapter 19 that's still the problem.
Yes.
Okay, got it.
Well,
Just want-
Would there would potentially be there would be a transcript from a court of record, right?
yes.
So from the court of record, there would be a transcript. It's just that there's not a transcript coordinator. So that
Okay.
request would go to the court clerk.
Okay, and the transcript would still be required in these types of
From
appeals.
the courts of
Okay.
record.
So we
Yeah.
still need to make a change to 138.081.1B. Okay.
Yeah.
Got it.
I have a question. If there is recording like tape, which is what, or digital, and nobody has typed up a transcript of it, isn't that still the record? Jim, you remember back in the old days, in district court, there were tape recordings, and there were oftentimes no transcripts typed up.
I don't recall whether it's by statute or by appellate court rule, but transcripts are now required in all cases unless one files a motion with the appellate court for waiver of that requirement and for leave to proceed on the audio record, which are never granted. Those motions are occasionally filed, but the appellate courts almost always say, nope, we want a transcript.
Then who prepares it? And it doesn't
Uh,
have to be an official transcriber? I'm sorry
Yes.
for asking the question.
Yeah, no, well, yes, because under chapter 19, yeah, the clerk of the court is responsible for identifying a transcriptionist who then prepares the official transcript, and the appellant then has to pay the transcriptionist rate charge for it.
Okay.
Okay, we are about at our hour here, so perhaps we should table the rest of this for another time. Katie?
Hey, I'm so sorry to chime in. I just
No,
looked,
please.
and I'm a little slow here, so I'm moving back on the ORS 19240, and I saw that the revised proposed language, instead of referring to the transfer coordinator.
I'm having a little trouble hearing you. Are you able to maybe get a little closer to your mic?
Yeah,
Sorry.
I'm so sorry. Can you guys hear me okay now?
It's about the same. Perhaps I can turn my volume up.
I'm so sorry. I don't know why Can people hear me now? I can also send an email if that would be easier.
That's a little better for me. How are other people able to hear? Okay.
So I just wanted to just flag that I saw that I was looking over the revision on ORS 19240, which is section going back to section 10, I believe. And just the change to the designation of the circuit court. I just thought I might check in with my folks if it should be more clearly defined, just so it's not a blanket just circuit court, and it should be designated to maybe a role or responsibility at least, so it's more clear, so it's routed instead of maybe just going blanketly to the circuit court and then it could get lost in the shuffle, if that makes sense. So I just wanted to flag, I thought I'd just take a quick look at that. And my apologies for slowing it down if that's problematic.
Further
I mean,
comments? Sorry, go ahead.
I think the practice is that when anything is either handed across the desk or mailed in or as modernly done, e-filed, everything gets routed to the trial court administrator's office. And so I think it's enough to say that it gets filed with or served with the circuit court. Because it ends up in the same, it all ends up in the clerk's office, but it certainly would be no harm for you to check into that to see if there have been any problems with it. I don't think so, but maybe.
Thank you so much. I appreciate your patience and dealing with my terrible mic. Thank you.
More questions are always welcome as we're sorting through this, and we have more time, don't worry. Sandy, I think our next step is to schedule
Yeah.
a bridge group meeting.
Well, without Justice Duncan here, I wanted to be careful to get anything scheduled officially. What I think I'm going to do, because we actually want to schedule this group, we also want to schedule the larger group, just to do an update sometime in the next 2 or 3 weeks, hopefully. What I'll do is, Krista, I'll reach out to you and to Justice Duncan. I know she's traveling today, to find out some times he may be available, and then I'll likely send a scheduling link just to the rest of this group and then to the larger group to schedule those meetings. Hopefully, depending on Justice Duncan's ability to respond, I know she's been traveling for family issues. Hopefully get that out by tomorrow. Does that sound like a plan?
And I think that as far as the large group meeting, it would be to go into some of the decision points that
Yes.
we've identified. And so we'll have to, we'll distribute a list essentially of some of those decision points that this group has identified.
Exactly.
I wanted to ask a really quick question about the draft, because I now have identified our last 2 meetings have identified changes that need to be made. And I'm
Yeah.
wondering if you wanted an updated version or, okay.
That'd be amazing if you have time, if you could get us one, and then I'll get that redistributed both to this group and to the larger group.
Okay, sounds good.
Thank you, Jessica.
Is there an easy way for you to track changes so we know what you've done from our first draft?
There really is not. Okay, actually, I could convert it to Word, I think, and then do it that way. It would just look very different. It would be a Word document, not what our program usually spits out, which is what the group has been working with.
I think that's okay. I think it's easier to have that, and then as long as you're able to incorporate that back into the software you need to do the final copy, is that okay?
I mean, it wouldn't convert back and forth at all, really. I'd have to do it twice. The other option would be just using some like physical marker, like asterisks around every change that I make. And then I could go back and remove those.
I like that. I think it would be really helpful for us to be able to not have to remember what we had already gone through.
Okay. Me and Victor will consult and we'll try to figure out some way to indicate what changes have been made.
Thank you. Sorry for the extra work.
Okay. Anything else before we end for the day? Okay. I'll stop the recording.